All rise. The Court of Appeals, Division 1, is now in session.
Thank you. You may be seated. Good afternoon. We're here today in our case number CV150562, First Southern National Bank versus Sunny Slope Housing Limited Partnership. Paul Mashney, the court-appointed receiver, is the appellant. We're delighted to have sitting with us today former Justice Rebecca Birch is filling in due to the absence of, or the retirement of some of the members of our court. These proceedings are being audio and video recorded, so we would ask you to identify yourself and the name of your client when you approach the podium for the first time. Each side will each have 20 minutes. Appellant will be responsible for reserving any time you'd like for rebuttal. We have conferenced this matter. We've read the briefs. We hope we're familiar with the case and the issues. And with that, we'll proceed.
Thank you, Your Honors. May it please the Court, John Maston O'Neill appearing on behalf of the appellant receiver, Paul Mashney. For purposes of the argument today, I'm going to refer to Mr. Mashney as the receiver. It's just the easiest thing to do. The reason why, and I shall say I also reserve any time I don't use for in this opening for rebuttal. The reason why we're here is because the receiver was denied reimbursement of attorney's fees and expenses that he incurred in administering a receivership estate and also defending himself against allegations in both the bankruptcy court and in the superior court that he had done wrong and that he had exceeded the terms of the appointing order. In reality, in what I'll call Mashney 1, the Court of Appeals ruled that Mr. Mashney, the receiver, was entitled to judicial immunity, and therefore those claims which were asserted against him could not be sustained as a matter of law. Mr. Mashney originally found himself applying for reimbursement of fees and expenses with the Superior Court because Judge Haynes, the bankruptcy court judge in 2011, in a partial stay order, ordered that after the bankruptcy was filed, the receiver go back down to the Superior Court and wind up the aspects of the receivership estate. And at that time, there were noises being made by Sunny Slope Housing that claims should have been asserted against the receiver for the actions we talked about or I mentioned previously. Subsequently, in February of 2014, the bankruptcy court, albeit via a different judge, declined to rule on the receiver's application for administrative expenses on the grounds that the receiver needed to go down to the Superior Court and have that claim liquidated and then bring it back to the bankruptcy court for determination under the administrative procedures of the bankruptcy court. And that's exactly what the receiver did. After having seen both the stay relief and then also that order to go back down, he approached the Superior Court, submitted an application for reimbursement of fees supported by 2 affidavits, supplemented at least twice, plus redacted billing records showing the fees and expenses that were incurred by the receiver in the defense and during the course of him serving as a receiver. Rather than rule on the merits of that request and liquidate the claim, the Superior Court, and this is where we believe the Superior Court erred, passed what we thought was a judgment or a decision on mootness. In sum, what the Superior Court said was, I'm not going to rule on this application, and I'm not going to liquidate your claim, because as I read the appointing order, the only way you can get paid is if there is money in the receivership estate. You concede that at present there is no money in the receivership estate, which was true because it had to be transferred over to the bankruptcy court pursuant to the code. And therefore, your application is moot because you can't be paid. Judge, and judges, we believe that was in error. There is a significant difference between liquidating a claim, which is exactly what the receiver asked to be done, and then asking the court to order that said claim be paid. And the receiver did not ask the court to do a futile act, i.e. order me be paid from money that isn't in an account. The receiver asked the trial court to simply liquidate the claim so he could take that and go to what at the time was the most likely source of recovery of funds, that is the administrative claims process in the bankruptcy court. Now, there are multiple other avenues from which the liquidated claim could be paid, and because this whole case evolved over the course of 2011 through 2015, many things have come and gone, but it's illustrative of where the money might come from when and if the claim is liquidated in order to be paid.
Mr. O'Neill, is there anything in the appointing order that limits where payment for Mr. Mashney and his counsel would come from?
In my view, Judge, no. As a matter of fact, the way that the order is written, it is not inclusive in the sense that it says thou shalt be paid only from these sources. What it is in the form of a permissive order. And it does identify in its text at least two areas from which the payment could be made. For example, the receiver is permitted to apply for a loan from First Southern, which loan would be evidenced by typical receivership certificates deposited and then used to reimburse the expenses. Similarly, the appointing order contemplates if there's income and money that are being generated during the course of the receivership that can be used to make periodic payments. And there is a very inclusive language at the end of the order talking about if further and additional relief is required, you're certainly permitted to come and ask this court for the same. I didn't quote it exactly, but that's generally the term. I also believe that the trial court did err when it suggested expressly, if not impliedly, that the only source of funds could be from monies in the receivership account. And there are other areas of money from where it could come from. The administrative claim, which under the current plan has been ordered to pay 100% by the debtor. So if the claim is allowed in part or in whole, money will be there. Similarly, the entire validity of the plan is on appeal in front of the Ninth Circuit. If you'd asked me a few months ago how strong I thought the chances would be that it would be overturned, I'd say pretty good, because the three-panel opinion, in fact, ruled that the plan be sent down. But as your honors may know, recently the Ninth Circuit granted a hearing en banc to visit that decision. But regardless, there is the possibility that, in fact, the plan will be reversed and gets sent back down to the bankruptcy court. If that occurs, one cannot rule out, and using the language of Vinson and Cardoso, there is a possibility that a bankruptcy plan cannot be confirmed. And in that instance, the assets that were transferred to the bankruptcy estate will be revested back to the receiver, including the property, the income, and the insurance proceeds. Those all could, again, be a source of payment. Similarly, Judge, I refer to the portion that there could be a loan, and the case law holds that the receiver does have the right to pursue a creditor for payments if the receiver so desires. And to your point, Judge, that avenue is not precluded by the order. When the Superior Court said, in sum, you're asking me to do a futile act, you are only allowed to get it from this source, and there's absolutely no possibility that you're ever going to get it, the court simply erred. What the court respectfully should have done was exactly what we narrowly requested. Please liquidate the claim that is in front of you and then allow the receiver to seek reimbursement and payment of that from the sources that are in fact available.
Can I ask, is there anything that would have kept the federal court or the district court from simply ruling on the fee request? It seems a little bit different than another type of claim, say a personal injury claim that needs to be liquidated in state court. If the court had said, I'll review the fee application and determine how much should be paid, is there any impediment to the court doing that?
If I may answer your question in two parts. One, I wasn't there, so I don't know what the court said outside what is written in the minute entry that was issued. I will tell you I'm not aware of a compelling requirement in the bankruptcy code that precluded the court from making a said ruling. What I do believe, Judge, that should be inferred and determined from that is the bankruptcy court looked at the stay relief order and then said, I'm not going to get into the business of determining whether or not what the receiver did or didn't do was within the terms of the appointing order from the Superior Court. I'm not going to be the one that makes the determination of whether or not those fees were reasonable and related to the tasks that the receiver was charged with. That is a task that is best suited to the Superior Court, i.e. the appointing court. And that is the reason why, Judge, I believe the bankruptcy court judge said I'm going to defer on it. I suppose the practical effect, Judge, is whether there was a legal preclusion or not. The reality is the court said they're not going to do it. And the court was clear that the reason why I'm not ruling on it is because I think your claim needs to be liquidated.
Does the bankruptcy court have the authority to say, I disagree with what the state court said in terms of whether it was within the scope of the receiver's ability or authorization, so I'm not going to award those fees?
Not in this instance, Judge. This is different, I believe, from a situation where you might have a vendor who would come to the bankruptcy court with the bill which hadn't been vetted by anyone prior thereto. This is an instance to where the court granted stay relief in order that the matter be determined pursuant to state law, i.e. compliance with the order, etc. And then upon that determination, I believe that is res judicata, and the bankruptcy court cannot come back and revisit it. Now, the bankruptcy court can, for example, say, I believe that you don't fit within the qualifications of 503B1, 2, or 3, or I believe that this isn't a properly reimbursable expense pursuant to the administrative claims process, or I think you really should be treated as an unsecured as opposed to something else. All of that clearly is with the ambit of the bankruptcy court. But I respectfully disagree, Judge. I think this is very much like a situation where if you had a tort claim or something like that that was reduced down to the state court and then liquidated by verdict or decision or otherwise, the bankruptcy courts do not go back and say, gee, I thought the jury was wrong. The bankruptcy courts take those claims at face value and then administer them under the code as required.
So you're saying the bankruptcy court presumably would be able to say there's no money from which to satisfy that claim?
Yes. Under the current circumstances, Judge, I don't think that would occur because the plan as it sits, which is status quo, requires 100% payment upfront and not over time of all administrative claims. So if the claim is presented and approved, it has to be paid. And there are monies in the estate and that was made available pursuant to the plan in order to pay said claims. I couldn't predict what happens if the plan gets reversed, but under the status quo, there are funds to pay and it has to be paid.
The judge did seem to fear that this would be an advisory opinion, that why should I give a number when the bankruptcy judge is free to disregard it? So you think he was simply wrong about that?
I think what he did was, Judge, he made an advisory opinion as to whether or not it was going to be allowed under the bankruptcy code. And he was in error in doing so. That was a decision that should have been left for the bankruptcy court. He did not say, I'm giving an advisory opinion if I pass on the issue of whether or not fees are allowed pursuant to the appointing order and whether or not the amounts that you're asking for are reasonable. A fair reading of the 9-page order, and it is long and it is detailed, that is clearly where His Honor Gerlach was going. He thought and he articulated that the reason why I'm denying this is because I believe even if I liquidate it now, when you go to the bankruptcy court, it's just going to be rejected because you haven't demonstrated that what you did redounded to the benefit of the bankruptcy estate. Respectfully, Judge, we think he was wrong. We think that the receiver could qualify for any number of items under the bankruptcy code which doesn't require an analysis of benefit to the estate, including excused custodian and the reading case exception. But no, Judge, I think that he was honest in the view that it was an advisory opinion, but he wasn't. I don't think he was claiming that he was giving an advisory opinion on whether the order allowed it and whether the number was reasonable. With that, Judges, I will reserve whatever additional time I might have for rebuttal. Thank you.
May it please the Court, Susan Freeman on behalf of Sunny Slope Housing Limited Partnership. First, let me start off by saying that this is not a gotcha case in the sense that we are not contending that they can't go to the bankruptcy court and pursue their administrative claim because they haven't liquidated, in his words, their claim in the receivership court. The fact that the receivership court said that this is moot does not stop them from going to pursue their administrative expense claim in the bankruptcy court, and we would never contend that it does. And when this court rules, it will be judicial estoppel against me, that it's not really a question. This is not preclusive. If you affirm this judgment, it doesn't stop them in any way from going to the bankruptcy court to pursue their administrative claim.
So when they went the first time and you objected, that was on the basis of the merits, not on a procedural
Absolutely.
matter?
And we still have a lot of objections on the merits. We don't think that they're entitled to certainly all of the claims that they have that they've asserted here for a number of reasons. But that is for the bankruptcy court to decide. This court didn't need to decide it, and neither did the receivership court.
Why doesn't it make sense, though, to have the state court to decide it, since the receiver was appointed in state court, and the state court has observed most of the receiver's actions? Wouldn't it make sense to have the state court determine in the first instance the outer bounds for a fee award?
And I think that that's what the bankruptcy court did. And let me note parenthetically that you don't just have to look at the minute entry order. The entire oral argument, the audio transcript is available online. It is docket number 636. And what happened was that the receiver asked that the bankruptcy court defer ruling, and the bankruptcy court agreed to defer ruling because most of the actions in this case had taken place in the receivership court. So it said that it would like to hear from the receivership court first. It didn't say you liquidate the claim. It said that the fee should be first determined in the state court, and made very clear on the record that the bankruptcy court was reserving its right to go ahead and change any such ruling, and that is entirely appropriate. It's in accordance with what the United States Supreme Court has said for a very long time. If you go back to the Gross opinion, it's not just a matter of who can pay, but rather who determines it. The Supreme Court said, when the bankruptcy court acquired jurisdiction, the sole power to fix such compensation of a receiver and fees passed to that court. That's the court that makes a decision. And in the Randolph and Randolph v. Scruggs case, the Supreme Court said very clearly that the fees for advising and counseling the receiver in respect of his duties and resisting the adjudication of bankruptcy were not payable. And it said that no ground appears for allowing services in resisting these things, and we are not prepared to go further than to allow compensation for services which were beneficial to the estate. There is a different requirement in bankruptcy. I happen to be one of those weird people who does both bankruptcy and appeals, and I can tell you that if you look at Section 543C and Bankruptcy Rule 6002B, and Section 503BE, I mean, they're very clear that it's the bankruptcy court that makes this determination.
But doesn't, in practice, doesn't that simply mean that the Superior Court, who saw the actions of the receiver in Superior Court, could make an assessment of what work was reasonable there and set an amount, and then it could go back to the bankruptcy court, and the bankruptcy judge could look at it and say, but some of that didn't further the bankruptcy estate and so forth. So it sounds like what you have is a disagreement with counsel about whether that amount that the trial court set, the Superior Courts, whether the amount that would have been set there was an absolute, would have been res judicata in the bankruptcy court, other than determining whether there was money in the estate and the priority of the payments and so forth.
Right. The bankruptcy court would look to see whether it was reasonable, would look to such things as whether, as required in the bankruptcy, when you have a superseded custodian who comes in and operates the the estate for a while after it's in bankruptcy, that the custodian's attorneys have to be court approved before they can get paid. They weren't court approved here because they didn't apply for court approval until just before the actual turnover of the estate, when the court was already making the decision to turn it over. So it's not just did it benefit the estate, but also whether they comply with certain procedures in the bankruptcy case. So there are requirements that would be in. Now, in this particular case, this was a situation where a lot of the alleged wrongdoing, actions that we think were wrong, took place when it was all in Superior Court. And so it was perfectly understandable from the bankruptcy court's viewpoint to defer to what was requested by the receiver and get the input from the receivership court. But that doesn't mean the receivership court had to do it. It doesn't require him to do it ever. The case law is clear, the code is clear that it's the bankruptcy court that makes those determinations. So if the receivership court said it's an advisory opinion, as they said in the oral argument, all of this will be re-reviewed through the prism of bankruptcy and acknowledge that this is not a final determination when they were there in the receivership court, as was appropriate. So the bankruptcy court didn't require it. The receivership court wasn't obliged to give an advisory opinion to the bankruptcy court. I think as a practical matter, he did so. He did offer his views in saying that the application for the receiver's own fees was completely unsupported, and that the application for the attorney's fees was inadequately supported. We would contend that those are findings of fact and that those would be something that we would seek to assert collateral estoppel effect on in the bankruptcy court. Again, not something for this court to have to deal with. But he did offer his views, and so the bankruptcy court can look at that as well as looking at the other requirements of bankruptcy.
Are you suggesting that did the bankruptcy court err by sending it back? Did the court was it obligated to just rule on the fee request in the bankruptcy court? Was that something that the bankruptcy court should not have done, in your view?
I guess as I see it, it's similar to your requesting or a federal court requesting an opinion on a certification from the state court saying, tell me what the state law is, or tell me what happened in this court. I don't see that request for an advisory opinion that did not require it to be given was an error, but this court doesn't review the bankruptcy court for error in any event, so I guess it doesn't really matter. The point is that there is no receivership estate now, and there won't be a receivership estate again. To have a receivership estate, again, you would have to have an entirely new receivership order. This receivership estate is done. There is a final decree. The receiver has been discharged. The bond has been exonerated. That has not been appealed. The receivership is over. So even though the receivership might have obtained loans at one point in time, it can't do it now. The receivership is over. The receiver does not have a claim. The receiver does have his own claim in the bankruptcy case, and it's I guess a little bit unusual in the sense that the receivership is over. We did try to do some research on that to see in what capacity the receiver could do such a thing since the receivership is over. We would cite the court to the Clark on Receivers section that the receiver has cited to you, 697A, which says a receiver may appeal from an order disallowing him commissions or liens because that affects him personally. And I guess I see this as the equivalent of a trial court entering a sanctions order against attorneys and saying you don't get your attorney's fees, then the attorneys can on their own go ahead and proceed even if their clients don't appeal. It's a personal choice that they can make to go ahead and pursue it even though the receivership is over. Now, this citation goes on to talk about how the receiver can have a holdback of the amounts that are turned over, and then there is some kind of an estate in a receivership estate that you could hold on to and collect from. And we've cited other cases that we're saying if you want to appeal or pursue something and keep a receivership estate, then when the receivership estate is terminated, the receivership court must withhold jurisdiction to allow something else to happen. It didn't happen here. They didn't ask for it. It didn't happen here. So the receiver does have his administrative expense claim in the bankruptcy court, and he can go ahead and pursue it. The receiver can go ahead and seek fees from the appointing bank, and he has cited nothing, and we have found nothing that says you have to have a receivership court order determining the amount of your fees before you can go back and seek to have them collected from the bank. So if the receivership court declines the rule, that doesn't stop them in any way from asking for that money from the bank. With respect to their other alleged source of payment, a claim if the bankruptcy appeal is overturned, the turnover of funds to the bankruptcy estate by the receiver has not been appealed. That's not the subject of an appeal. The turnover of the hail damage proceeds is final. The plan said what the hail damage proceeds were to be used for. That's final. That was never appealed. There was an appeal by the bank, and the bank is the only party to the appeal, not the receiver. So if there is a reversal, the debtor in possession will be back in control, not the receiver. Receivership is done. The debtor in possession will be back in control. The debtor in possession can argue and try and come up with a revision to the plan if in fact it is reversed on some grounds. We don't think it will be reversed at all, but if it is, that's what would happen. The receiver does not come back in, and the receiver doesn't get to take possession of something. Once you have a bankruptcy, the receivership estate all goes over to the bankruptcy estate and becomes part of the bankruptcy estate.
Would your position be the same if this were a personal injury claim that in the bankruptcy court said, I need to have you liquidate that in state court?
Yeah, that's different, and that's much more the common thing. When you're talking about professionals and receivers, there are specific code sections that deal with that, and those were cited in the briefs. But those are different than saying you've got a normal unsecured claim that you need to have determined, and it was the subject of pending litigation, so you get it resolved there rather than starting the litigation anew in the bankruptcy court through an objection to a claim procedure. That's a normal kind of thing to do.
I don't disagree with your statement that the fees for Mashney and his counsel could be litigated in the bankruptcy court, but you used an interesting analogy that it's like a federal court certifying a question to a state court. Usually when they certify a question, it's to the Supreme Court, and if the Supreme Court gets it wrong or declines to rule, there's really nobody to look at over that. To follow that analogy through, here we have a situation where it was certified, if you will, to the state court, which really did have a better opportunity to review the work that Mashney and counsel had done. But he declined to review it on a couple grounds. Let's assume for the moment that an appellate court looking over what the trial court did and having the ability to do that, what if it disagrees? Should it then order the trial judge to review this using proper standards, or should it just say, you know, it was a request for certification, he declined to do it for whatever reason, we should let it go?
Well, I guess my analogy of certification is probably not entirely it, because that's asking for a determination of law as opposed to really a factual determination, and that's what we're talking about here. You know, the factual of whether the work that was done was reasonable and was reasonably supported in this record. And the court did make its determination that it wasn't reasonably supported. And as a practical matter, Your Honors, if you decide to send it back down, you can cut and paste and give it right back to you and make that a finding of fact rather than a mootness ruling. But no, I don't think that it is the same, because you do have specific, as I said, code provisions and long-standing law coming from the Supreme Court that it's the bankruptcy court that makes the final determination, fixing the fees, not just taking what somebody else determined and applying the order of priority and making a payment determination. Instead, it's the actual fixing of the fees that need to be done in the bankruptcy case. So it is a little different in the sense that the bankruptcy court does have jurisdiction to overrule effectively anything that would be determined by the receivership court. I guess I want to note also that the mootness determination, I know we have alternative views of the law as to whether this is a de novo determination or an abuse of discretion determination by this court. The case law is pretty uniform that it's a prudential discretionary determination. So usually a discretionary determination is reviewed for an abuse of discretion, and we have, and this is not something that has specifically been ruled upon by the Arizona appellate courts. I can see that there are some cases going each way. I guess I would point the court as the case that I think might pull them together most by looking at the Hunt decision, which is cited by the receiver, and it says de novo whether the court has authority to issue an order and an abuse of discretion as to the exercise of that authority. So the receivership court has the receiver who's been appointed, and he needs to close down the receivership estate and issue the final orders and approve the final report. He had authority there to do it, but he certainly had discretion to say, this is an advisory opinion. There is no receivership estate funds for me to pay. The receivership order says I only make determinations about the receivership estate. I don't want to spend my time advising the bankruptcy court for the bankruptcy court to supersede that decision. And that deferral to another court, an exercise of comity, certainly is something that is determined on a discretionary basis on appeal.
You're agreeing that it would not have been error to issue a decision saying this is how much I think would be reasonable to compensate the receiver?
The court could have done that. It would have been, as I said, an advisory opinion that the bankruptcy court could entirely supersede, because the bankruptcy court would have to look at it, would have to fix the fees. It would be advice from the Superior Court.
But if we're looking at it in terms of did the Superior Court abuse its discretion, when the bankruptcy court asked for the opinion and there's nothing that prevents the Superior Court from offering that opinion, and in fact it seems like the Superior Court's in the best position to assess the fees that were assessed in state court proceedings, would we find that that's an abuse of discretion?
Yeah, and I guess I would point to the court that from the trial court's perspective, you do have lots of cases saying you don't have to give an advisory opinion. You shouldn't give advisory opinions. And to tell the court you were asked to give an advisory opinion, you have to do it because a bankruptcy court asked you to do it, so therefore you have to do it. I mean, to me, that's really, I think, going beyond what the law should be, what the court should be doing in terms of telling a lower court how to spend its time. The court could have done so, didn't have to, was entirely within its rights not to do so, especially given the lack of a receivership estate. The receivership order saying you're making determinations about payments from the receivership estate. They're no longer being a receivership estate. There's just, I don't see that there was anything wrong with what the receivership court did. And as I said, the bankruptcy court did not require it, did not say you must do it, did not say you must liquidate it, and instead was saying that it would appreciate a first determination, but that's not something that was necessary. Let's see if I had any other notes here that I haven't gotten to. I guess only that we did cite cases at pages 35 and 36 of our brief that talk about mootness when there has been no stay in the receivership. Assets have been distributed. When the receivership is over, then this is moot. And the trial court was entirely within the law in saying that it was moot. The receiver said we didn't raise it below. The receivership court was the one who came up with the word mootness, but we did argue below that there is no receivership estate, that only the bankruptcy court has jurisdiction at this point to make that determination, and that it was just an advisory opinion. So the appellation of mootness that the receivership court put on that, I think is entirely appropriate within the law for it to do. Let's see. I already talked about the discharging without reserving rights. The bankruptcy, they did not hold back funds at the point in time that they transferred it over. Oh, the other point is that when I did go back and listen to what the bankruptcy court did, and again, this is available by listening to the transcripts there, that when they came in and initially asked for a when the receiver was resisting turnover of funds, he was saying, I want to have this money back to pay for the receivership then, or the receivership fees and expenses. The bankruptcy court quizzed and discussed at length about 543 of the bankruptcy code and 503 of the bankruptcy code and so forth. And the ultimate determination was you have an administrative expense claim, which is top priority. So you don't need to reserve anything. These funds are the proceeds of the receivership estate, which became the bankruptcy estate. We now have a plan, and that plan has been confirmed, not this particular aspect not appealed. The turnover order was not appealed, that said it's going to be used to pay for repairing the roof. And so the court said, what you have, you don't have a holdback right. What you have is a right to an administrative expense claim. They did not appeal that. So any other questions from the court? Thank you very much.
I'd like to first address the notion that the appellee is going to come to the bankruptcy court and say everything's free, everything that the trial court did was advisory. Respectfully, that's not what's in their brief. If you note on page 15, they've reserved every right that they have. And counsel alluded to the ruling from Judge Gerlach that, in fact, maybe his alleged determination on reasonableness, i.e. that there was no evidence to support reasonableness, is now res judicata, which will be taken to the bankruptcy court. So the true state of the record is this hasn't developed in the sense to where the parties filed their briefs thinking, wow, the bankruptcy court just made an error by suggesting that you go down to the trial court. Everyone thought that we were in front of the trial court to have it liquidated, and then we were going to go back to the bankruptcy court. On the analysis of reasonableness, and in your honors, I will admit there is no specific law in Arizona dealing with reimbursement of fees pursuant to a receivership order, but I can argue by analogy. This is not an instance like a fee claim under 12-340-101, which the trial court is granted discretion to deny the fee request in its entirety. The appointing order, which I would make akin to a contract with a fee provision, says the receiver is absolutely entitled to fees. And in that instance, what has to happen, even if the court finds that there is evidence of unreasonableness pursuant to the case law, the Elston case, and I believe it's Geller, the trial court still has to determine reasonableness based on the record that it has. It doesn't have the discretion to say zero. Now, respectfully, I don't think that's what the trial court did here. I think what the trial court said, and if you read the language, it said, I don't have enough evidence in front of me to determine whether or not fees should be awarded because you haven't submitted with your application and affidavits evidence showing that the work benefited the receivership estate. And even then only pointed to specific examples. I think the total was $67,000 rather than saying that problem infected the application and every line item that was asked for. So respectfully, this isn't an instance, I think, Judge, where it goes back and there's a discretion to deny the request in its entirety. I think some fees have to be awarded with the rubric of reasonableness.
Do you agree with opposing counsel's statement that the receivership is over, so there's no way that the receiver at this point could go back and try to get?
No, Judge. And the best that I can point to that is if you look at the notice of appeal that was filed, and this directly rebuts the argument from counsel, the receiver did not appeal only the order with respect to the fees. The receiver appealed the entire order and any intermediate orders. What happened was everyone went down to the Superior Court, and candidly, nobody thought that the judge was going to be issuing a decision saying that it was on mootness because that hadn't been briefed, and it came candidly out of the blue. And then also what happened, Neither party had submitted or lodged a proposed form of judgment following the ruling in order to adapt to what the trial court said in the July 14 order. What the trial court did is turn that minute entry ruling on the denial of the request into the final judgment by signing it and including Rule 54 language in it. So, Judge, the real question is, was the entire judgment appealed? Yes. What should happen, assuming that you find some error? It should be revested back down. The entire order should be reversed, and then the proceedings go according to whatever instructions this court might make. There was an allusion to there's no appeals in the bankruptcy court that could otherwise affect this. That's incorrect. As I suggested in my argument and opening, the entire validity of the plan is at appeal. And if the plan currently in place is reversed, it has to go back down to the bankruptcy court to determine whether or not a plan can be confirmed or not. So we're starting with a clean slate. And one of the possibilities, using the mootness analysis that's in Cardozo and the Vinson cases, one of the possibilities is no plan can be confirmed. In that instance, the bankruptcy will be dismissed, and all monies will revest back to where they were, including the insurance proceeds, the property, and the income related thereto. With that, Your Honors, if you have any other specific questions, I'm happy to answer them. If not, I'll rest. All right, thank you, judges.
Thank you both for your arguments. We'll take this matter under advisement and issue a decision in due course. We'll take a brief recess and be back for the next case shortly.